We'll finish up this unit by looking at some of California's online privacy laws. And as I said, we look at California for various reasons. Each year we have to adjust our policies and practices, and it's common practice for CISOs to use the most strict available guidelines as a baseline for their practices. That way, if you meet the most strict requirements, then all other states will be in line with your privacy requirements. So you continuously review the state and federal policies for changes. California leads the nation in some of the strictest, most comprehensive online privacy laws. Importantly, the California laws tend to address important issues facing the internet world, and that's why I think they lead the pack in trying to understand and set forth privacy regulations that protect individuals' privacy on the internet. The California privacy laws often present a challenge, though, to corporate security teams because of their restrictiveness. Sometimes it puts the onus on the companies to find new ways of handling data or collecting data or presenting interfaces to the clients that can be very costly to implement. The California Online Privacy Protection Act, or CalOPA, was instituted around 2004. And in that time frame, there really wasn't a need or a requirement to post a privacy policy. But it was generally accepted that if you did post a privacy policy, that it had to reflect the actual practices that were in place. Well, CalOPA required that all companies that collected personally identifiable information must conspicuously post a privacy policy. So this required a company to address two issues. One was designing a privacy policy and designing and implement the actual practices behind the policy. Now, I don't know if it's a chicken and egg kind of thing. Do you design the privacy policy and then institute the actual practices behind that to make sure that they match up? Or do you match up the privacy policy with the practices that you have in place? Well, in actuality, it's probably both, because those practices which don't match other aspects of California law or Massachusetts law or whatever, you'll certainly want to have updated before you write your policy, and then your policy would then reflect your actual situation. So CalOPA set certain minimum privacy policy elements, such as categories of personally identifiable information collected, categories of third parties with whom data might be shared, descriptions of any processes that the consumers might use to review or request changes to information, descriptions of processes that notify all users of material changes, and establishing effective dates of the privacy policies. So an important aspect of effective dates of privacy policies are that as privacy policies change, or as regulations regarding privacy policies change, you still need to keep track of old privacy policies, because if a lawsuit takes place or is filed against you for an activity that took place in the past, you want to know what privacy policies and security policies applied to the organization at that period of time. So you want to make sure you keep track of all that information and all those policies. And a description of how to do not track request and how that'll be handled also needs to be maintained. So personally identifiable information on an individual is the first and last name, home address or other physical address, email address, phone number, social security number, or an other identifier that permits physical or online contact of an individual, or any combinations of these elements. And there are variations in California statutes that go further to define what the elements of personally identifiable information are. So you don't want to just rely on one law. You want to look at the entire mix of California laws. The California Attorney General aggressively enforces this policy, and today CalOPA requires that mobile apps post a privacy policy as well. The California Shine the Light law went into effect in 2005 and applies to companies that have established business relationships with customers. It applies to companies that have disclosed personal information in the past calendar year to third parties for direct marketing. I'm not going to read through the categories of personally identifiable information, but you can see this is a fairly lengthy list of personally identifiable information. Some of the interesting ones are in the second column, in the middle of the second column: political party affiliation, kind of product purchased, your kind of services performed, age and gender of children. So these are things that certainly are personal information, and certainly could lead to being personally identifiable information. Upon request by the customer, the company must supply what information is stored on the customer for free. The company must provide contact information, either an email address or a mailing address, should the customer need to contact the company. And companies receiving a Shine the Light request must respond within 30 days. California minor eraser law is an interesting law. Went into effect in 2015. Places restrictions on website and online services and apps directed towards minors. However, it sets the age limit for minors to under the age of 18, not 13. And it provides minors a limited ability to request and obtain removal of content and information that the minor may have posted on the site. The site must provide the minors with instructions on removing data, and there's some limitations on the ability to do this. Another law that's very interesting is the Illinois Biometric Information Policy Act. It's used to limit the use of facial recognition and other biometric technologies. It defines a biometric identifier as a retina or iris scan, fingerprint, voice print, scan of a hand, or face geometry, and specifically excludes photography, writing samples, and physical description of the individuals. Biometric information, on the other hand, is information regardless of how it's captured, converted, stored, or shared based on an individual's biometric identifier used to identify an individual. What's interesting in these biometric laws is you don't see the DNA listed. And I'm wondering how long it'll be before we'll start seeing biometric identifiers, including the DNA that we collect through, say, these genealogical sites that are collecting DNA and holding those databases. So the statute was key to a May 2016 case where a federal judge refused to dismiss a class action lawsuit against Facebook. The plaintiffs claimed that Facebook violated the Illinois law with its tag suggestions program. So basically what Facebook did is it went out to the photos that individuals put out on the internet and in Facebook, scanned the photos and used facial recognition software to suggest tags to users to assign names to photos. Facebook claimed that the photographs were excluded from the law, but the court disagreed and denied motion to dismiss. The court reasoned that the facial recognition technology constituted a scan of face geometry, which is covered by the statute. So think about what Facebook was doing. So if you have an identified Facebook account, you stored pictures of yourself and your family out there, which you might have tagged, or you might have just had somewhere in the description that this is my brother Rick. But what Facebook was doing was capturing images, scanning those images in and doing facial geometry and recognition on the faces in the pictures and matching those up with identified names and accounts and suggesting that in other pictures that it sees out on the Facebook accounts that might be you, and then suggesting that they tag it as you. So anyway, in Illinois, companies must get consent before using digitized images.